Okay, let's go ahead and get started. Dean Buckner Innes.
Thank you so much, uh, Dean Kronk Warner. I am so pleased to be here with the several panelists here, with one of my Big 12 co-deans, Dean Elizabeth Kronk Warner. And I, first of all, just want to give a shout out not only to all of the people who will be participating in this discussion today, but especially to some of the younger members of our audience. There are several high school students, for example, that I've invited. And so I want to say, hey there, and thank you for being here and taking a part in what I know is going to be an incredibly informative discussion. With that, I'm going to turn it over to Dean Kronk Warner.
Great, thank you so much. And I'm going to echo Dean Buckner Innes's hey there. We are so very glad to have you join us for our conversation today. What does the law say about Minneapolis? My name is Elizabeth Kronk Warner. I have the privilege of being dean at the S.J. Quinney College of Law at the University of Utah, which is one of the Big 12 law schools that will be participating in today's presentation. And I do want to start off by acknowledging that today I come to you from the beautiful Salt Lake Valley, which is named for the Ute tribe and is the traditional ancestral homeland of the Shoshone, Paiute, Goshu, and Ute tribes. Very pleased to be here with you tonight. So we're excited because we have experts from across the country and across the Big 12 for what I know is going to be a lively and informative conversation. And what we've done here is bring faculty from across the Big 12 law schools together who will examine current events from a variety of legal angles. In bringing together these renowned experts, we hope that this collaboration will provide insight into the myriad legal issues arising from current events in Minneapolis. I'm going to keep my comments real short and briefly introduce our speakers because I know you all want to get to them and hear what they have to say. So after brief introductions, each of our speakers is going to have 6 minutes to present, and that should leave us with a roughly 12 or so minutes for question and answer after the fact. You can ask a question at any time. I'll be moderating the question. To answer or to ask a question, go ahead and put your question into the chat box. The panelists will see your question, even though it will not be shown to everybody who is attending. So again, if you have a question to ask, drop it into the chat box. So our first speaker today is going to be Emily Berman from the University of Houston Law Center, where she is the William B. Bates Distinguished Chair in Law, the Assistant Dean for Faculty Research Development, and a Professor of Law. She's a constitutional scholar with expertise in executive power and national security. She will then be followed by Violetta Chapin from the University of Colorado Boulder Law, who is a professor there with broad experience in criminal law. Next, we will hear from Jacqueline Green, who is both a partner at Friedman, Gilbert, and Gerdenstein in Cincinnati, Ohio, as well as serving as a faculty member at the University of Cincinnati College of Law. She will be followed by Mayor Quinton Lucas, who is both mayor of Kansas City, Missouri, Missouri, and lecturer of law at the University of Kansas School of Law. He will then be followed by Professor Mark Miller from the University of Arizona James E. Rogers College of Law, where he is the Ralph W. Bilby Professor of Law, and he writes and teaches about environmental law and policy and criminal law and policy. He will then be followed by Daniel Morales from the University of Houston Law Center, where Professor Morales is a scholar and theorist of immigration law. And last but certainly not least is my colleague, Professor Matt Toxin, who is a professor here at the S.J. Quinney College of Law at the University of Utah with expertise in Fourth Amendment and its application to new technologies and social contexts. So with that, I'm going to turn it over to Professor Berman for 6 minutes. And remember, if you have a question, drop it in the chat. Thanks so much.
Thank you so much, Dean Kronk Warner, and to the rest of the powers that be in the Big 12 for organizing this forum, and to all of you for being here to take part in it. So my brief remarks concern a topic that I've been working on this year, which is the erosion of internal executive branch checks on executive power in the second Trump administration. So just for background, as the powers of the American president have grown in recent decades, legal scholars and policymakers have offered various ways of imposing constraints on the exercise of that executive power. And one of these is what one scholar called the internal separation of powers. And the idea is that the traditional concept of interbranch separation of powers could be reimagined to encompass internal divisions of authority within the executive branch that could serve as sort of second best substitutes for the external separation of powers that frequently break down when it comes to contemporary executive power. And we could debate about exactly how effective these internal separation of powers mechanisms have been, but it's beyond dispute that in the second Trump administration, many of them have been either eliminated or severely weakened, including several inside the Department of Homeland Security, and that's what I'm going to focus on. So there are 4 offices inside the Department of Homeland Security, or DHS, that are designed to check power and provide oversight. First, there's the department's Office of Civil Rights and Civil Liberties, which is a congressionally mandated entity that oversees complaints about civil rights violations, including in the context of immigration enforcement and detention. In early 2025, its staff was cut from 150 employees to 9. And this is despite there being 550 ongoing investigations at the time alleging serious rights violations. Similarly, the second office, the Office of Immigration Detention Ombudsman, which is focused specifically on oversight of immigration detention, had their staff reduced from 110 to 10. Third, the Office of Citizenship and Immigration Services Ombudsman had their staff reduced from 44 full-time employees to about 8. Several of the former employees, particularly from the Office of Civil Rights and Civil Liberties, have filed a whistleblower complaint arguing that it's impossible for the office to meet its statutory mandate, which includes conducting inspections, responding to complaints, and functioning as effective internal accountability bodies at those staffing levels. So why have these offices been reduced to such small staff? According to DHS's public affairs official, the Office of Civil Rights and Civil Liberties, quote, obstructed immigration enforcement by adding bureaucratic hurdles and undermining DHS's mission. Rather than supporting law enforcement efforts, they often functioned as internal adversaries that slow down operations. Internal adversaries. This is the same kind of explanation that Defense Secretary Pete Hegseth gave for firing the highest ranking military lawyers. He said they were roadblocks to Defense Department operations. The point of separation of powers is to have roadblocks. And so when you eliminate them, you're really undermining our system of oversight and accountability. The fourth office in DHS, it's an interesting one. It's the Office of the Inspector General, which is an internal watchdog agency that exists within many different executive departments. And when President Trump came into office, he fired 17 inspectors general just in January 2025. The DHS Inspector General was not one of them, presumably because he was appointed during the first Trump administration, and so he was viewed as sympathetic to the administration's goals. Recently, however, he has reportedly initiated multiple investigations into ICE regarding the hiring surge, expedited removal of individuals, the use of force, compliance with detention standards, the use of facial recognition, and the collection of citizens' personal data. Now, we don't know what kind of investigation he'll conduct, or even whether he'll be permitted to conclude it. And in fact, in a recent hearing, Senator Tammy Duckworth noted that the DHS General Counsel had asked the Inspector General's office to disclose to them a list of all ongoing investigations and reminded the Inspector General's office several times that current law authorizes the Secretary of DHS to halt an investigation in order to prevent the disclosure of sensitive information or to protect national security. So it seems like perhaps a veiled threat. And so we'll see about how effective that investigation ends up being and whether any of the outcomes are made public. So these are DHS examples of a phenomenon that's taking place across the federal government. And they're important to keep in mind in this context, both with respect to the kind of behavior we've seen on the streets of Minneapolis, and perhaps more importantly, to the plan to literally warehouse upwards of 90,000 human beings. In Minneapolis, public resistance and documentation was able to substitute, at least in part, for the absence of these intra-governmental checks. The same is not going to be true for the detention facilities that are being built out, especially if they continue to defy existing law and deny legislators access to those sites. So this is a space to keep your eye on.
Thank you, Professor Berman. Now we'll move to Professor Chabin.
Thank you, Dean Kronk-Warner, and to all of my fellow panelists for being here, and to the audience for tuning in to listen to what we have to say. I'm going to talk a little bit about how it is that we here at the law school are talking with our students about what's happening in Minneapolis, and to share some recent events that have come up here at the law school in the hopes that it's helpful in moving this conversation forward as we talk both amongst ourselves, but also with our students about what is going on. So I teach a clinic at the University of Colorado Law School. It is a criminal and immigration defense clinic, and all of our clients are non-citizens. And they're either navigating a state criminal case or a federal immigration case. And so my students and I know firsthand how it is that immigration and customs enforcement, both in the form of ICE agents as well as ICE attorneys, are interacting right now with our clients, and none of it is any fun, right? All of it is very scary. Our clients are experiencing a level of anxiety, right, that I've never seen before, and I've been teaching this clinic for 15 years now. So since we have seen the events unfolding in Minneapolis, and after the killing of Renee Good and Alex Preddy there, the students at the law school, many of them, not all of them, but many of them, are outraged about what is happening, and they are looking for ways to object, which I fully endorse and agree with. I tell my law students all the time, if you see something that is wrong, you should object. You should object quickly and strenuously and coherently. And specifically what the students at our law school have done is a few weeks ago, they drafted a letter to our career development office asking them to remove a job listing that has been posted for ICE attorneys. They specifically work in the Office of the Principal Legal Advisor, or ICE OPLA, here in Denver, Colorado. The students want us to remove that listing because they believe right now that immigration and customs enforcement, and specifically the lawyers that are working for ICE or the Department of Homeland Security, are failing to follow the rule of law. And the students' position is that by the law school posting this listing for ICE is that we are endorsing the listing for ICE. This has caused us to talk with the students, and we have started to do that, certainly, about this, about whether or not, A, we were going to sign on to the letter asking our career development office to take down the listing, and whether, and what the students' goals were in doing this. I'm here to posit, right, that our position at the law school, and this is what we have shared with the students, is that one, we absolutely hear what they are saying, right? Which is that it appears that lawyers are violating the rule of law when they are standing up in court, and these are lawyers specifically for the Department of Homeland Security, and failing to comply with judicial orders, which is what we are hearing from judges in written opinions and in open court across the country when it comes to ICE attorneys appearing in courts. And then there's evidence that ICE attorneys are standing up in court and making material misrepresentations of fact, and that is a problem. The reason why we are unlikely to take down the listing is because it is our Career Development Office's job to make as many job listings available to all of our students as we possibly can. I have had several of my students over the years who have taken my immigration clinic and represented an immigrant in court go then apply for a job with ICE at the Office of the Principal Legal Advisor and become lawyers for the Department of Homeland Security. And perhaps it breaks my heart a little bit when they do that, but I am also happy that they have stood next to an immigrant already and understand how it is that an immigration case and a removal proceeding both affects the immigrant and their families. And I think that hopefully here at the law school, we are teaching them ethics, good ethics, so when they go into these jobs, they are then using those ethics and taking them with them. I suggested to the students that there were other ways, right, to meet their goals. For example, instead of us taking down the listing, that they could, for example, put up signs all across the law school that quote directly from the ICE attorney that appeared in Minnesota, who sort of lost it very publicly in front of the judge and said several things, including the words, "This job sucks." Her name is Julia T. Lee, and she appeared in court there in Minnesota and was completely overwhelmed by what was happening and what the judge was asking her to do, and the fact that the judge was telling her that she was failing to comply with court orders. And we suggested to the students that they could talk with each other very, very clearly and transparently about what they are learning about whether or not any of them should apply for a job with ICE OPLA right now. I talk with my students all the time about what jobs they might think about doing when they leave the building, and I do think it is incumbent upon them to think about whether or not a job with ICE OPLA today is a good idea or not. But we are not going to foreclose that opportunity for students who may want to work there and try to do something good. We also understand that this is something that has come up before, right, at both our law school as well, and is likely to come up in the future, where students have objected to certain employers being listed specifically on our employment list. This conversation, I think, is one that perhaps some of you are dealing with at your law schools, and it may be something that students who are attending this talk right now are also thinking about as well. So when we think about the rule of law and also the First Amendment, it's not always as clear as it seems, and I'm happy to be engaging in these conversations right now in this moment. Thank you.
Great, thank you so much. Next, we have Professor Green.
It's a pleasure to be here speaking with such brilliant people who are interested in what are really important issues facing all of us right now. And I'm appreciative of the invitation to join in the conversation. I'm just going to give an overview of a few things relating to what we've been seeing across Minnesota in response particularly to protests and some of the things that flow from that from the perspective of a civil rights litigator. And as a person who works with a lot of organizers and activists in that capacity as well, across Ohio in particular, but other places too. So for folks in the audience who aren't as familiar maybe with the First Amendment and the contours of what you can do with those First Amendment rights as a starting point, I think it's important to know, it protects, as we all know, right, freedom of speech, the press, assembly, petitioning the government, and free exercise of religion, and all kinds of other specific acts and actions that fall under those umbrellas. And to give some examples of what that means in our real lives, that's giving speeches, gatherings, parades, protests, rallies, demonstrations, all of those kind of public things we've been seeing across Minnesota. It's distributing printed materials, typed and written expression. It's teaching, it's researching, it's publishing and discussion of ideas like we're doing here tonight. It's also things like flag burning, symbolic speech, other acts along those lines, and also, of course, photographing and videotaping the police. And that has been a really essential part of what we've seen across Minnesota during the ICE actions and operations that have been taking place there. So the government can only limit your First Amendment expressive activities through what we call a content neutral and reasonable and narrowly tailored restriction and on the time, manner, place of speech, right? And I'm not going to get into the details of that. We talk probably a lot all night about the contours of what that means. But generally what that means is you can't be censored just for what your message is, right? And if there's any restriction, it has to be really as narrow as it possibly can be to accomplish a reasonable and legitimate law enforcement or government need or goal. In terms of the specific law enforcement responses we've seen in Minnesota, in the protest context specifically, there has been what I would call chilling of speech, intimidation of people engaging in First Amendment activities, retaliation for engaging in those expressive First Amendment activities, lots of use of force, including less lethal munitions, rubber bullets, impact projectiles, physical force of all kinds, physically putting hands on people, the use of chemical irritants like tear gas, pepper spray, pepper balls, smoke canisters, flashbang grenades, and more, including fatal and non-fatal shootings. And it's important to remember that this violence has been pretty widespread across Minnesota during the ICE operations there and has not necessarily been in response to what's often, I think, kind of described by the agencies involved as, violent rioters or other people engaging in unprotected actions not protected by the First Amendment. We also have had some conversation about what are the implications for Second Amendment rights in this context and what responses can or cannot be made by law enforcement in these circumstances, including ICE as they're encountering people if, for example, they are armed. And I don't practice in Minnesota, I practice in Ohio. But Minnesota is an open carry and concealed carry state if you have a permit. And generally speaking, unless there's an indication that a person's going to use a firearm under constitutional analysis, that the use of deadly force is not permitted in response to just the possession of or the presence of a handgun or a firearm. And that's particularly important in the investigation and the analysis of ICE fatal shooting of Alex Preddy. We've also seen detentions, arrests, charges for both protesters and media. We've seen criminal proceedings brought against those people. We've seen them detained. There's been a lot of stuff that is in the realm of police response and law enforcement response to protests fairly extreme. So the question comes out of that, what can be done to stop this? What can be done to prevent this, to ensure that the fundamental rights that are protected by the Constitution are in fact protected for people who are engaging in the exercise of those rights in Minnesota and anywhere else as ICE continues its operations around the country. And I think one of the critical things to keep in mind here is that, for anyone who is facing charges, of course, there are going to be constitutional grounds raised in the defense of their criminal cases, but also legal observers are an essential, I think, part of the response and of the documentation of what's happening, particularly in light of what we are seeing in the world of official investigations. There are repeated reports of the FBI blocking Minnesota law enforcement from accessing evidence relating to the death of Alex Preddy. The DOJ blocked investigation into the death of Renee Good. An FBI agent apparently resigned after he tried to conduct that investigation. So we're seeing a lot of challenges to accessing any of that information from federal agencies and blocking of other local agencies from actually engaging in their own investigations into obtaining that evidence. So when you need that information, how otherwise do you get it? I think that we've seen time and again in relation to use of force events, in relation to large protest arrests, in relation to these kinds of public displays of law enforcement power from ICE and otherwise, that public pressure is a really powerful tool, and releasing of records often results from that public pressure. In the meantime, legal observers documenting, and when I say legal observers, sometimes it's people who are trained for that role, and sometimes it's people who just happen to be on the street with their cell phone. It can be business security cameras. Any number of sources can be gathered and used for the purpose of understanding what really happened here. And all of that's really critical. I will just briefly, for my last 30 seconds here, just note, and I know other people are going to talk about remedies under the Fourth Amendment and what you can do through the court system to challenge these kinds of events. One thing that's really important to know in the realm of pursuing any kind of legal action against federal agents is that there's a whole avenue under the Federal Tort Claims Act that can be pursued, but it's got a lot of limitations. And I think one of the most important pieces of that is that any act that is discretionary function is an act that is not going to be able to be challenged through a lawsuit under that particular avenue. And I know I'm out of time, so I'll leave it at that for now, other than to just note the difficulty in challenging federal agent actions through courts and through any kind of litigation. Thank you.
Thank you, Professor Green. And next we have with us Mayor Lucas.
Hey, everybody. It is great to be with you and welcome to Kansas City. I'm in my mayoral office now, not sitting at the law school at the University of Kansas, although always happy to be there. Typically, my engagement with the law school is in what I find to be an interesting, but in some ways, ho-hum analysis of local government law. Of course, this year has been vastly more interesting, both as an instructor and then, of course, as a mayor. I'll start kind of with something that may be interesting to you, the discussion among mayors, then I'll talk about some of the challenges we're working with in Kansas City, how we, I believe, have made it dynamic to our students. Among mayors, of course, I've had the chance to talk to mayors in a number of your communities, for example, also Mayor Fry in Minneapolis. There are a few things that you're primarily seeing in municipal policy answers to the current moment. The first of which is for those cities that are looking to fight back, and that's usually most major American cities. It is looking at where we actually have to be compelled to work with federal agencies. Obviously, commandeering is something that cannot be done to us. So that's how you have sanctuary city status. That's how you have a number of folks that aren't looking to align with ICE efforts. Another area, and one that has been subject for debate, and I was on Face the Nation a few weeks ago, debating this with the dean of the Oklahoma City Law School, who happens to also be the mayor of Oklahoma City, which is, can we pass moratoria to ban the construction of gigantic ICE detention facilities in our communities, particularly, of course, where it relates to private contractors doing the work. The core of this issue is a really simple one. We recognized when there was talk about citing an ICE detention facility in Kansas City that it was likely to be a space of 5,000 to 10,000 people in a former Amazon distribution facility, and in no way was the zoning granted, although it was the type of zoning that allows manufacturing and broad sets of uses. It was not built with adequate sewers. It wasn't built with adequate needs for habitability of up to 10,000 persons. Fortunately, knowing a little bit about the zoning land use side of things, we thought that was our most aggressive location to act. And we, of course, have seen a lot of other cities either look to follow suit or to work with us in the meantime. Why is this not just immediately a supremacy clause concern? We've looked at case law in a few different areas in connection with it. The first of which actually comes fairly close to my city and close to Lawrence, Kansas, the city of Leavenworth, for a federal prison and an army base, perhaps. They have been in an ongoing dispute with CoreCivic, the successor to the Corrections Corporation of America, that have been looking to convert an ICE facility from a former prison. The claim by the city that has had some weight in Kansas state courts has been that you still have to go through the special use permit process for a facility and for a use like this, looking primarily less to the more interesting constitutional law issues and instead looking more purely on land use itself. The reason we require special use permits is because you have certain unique uses. You have certain draws and drags on infrastructure resources, roads, and others. It is fascinating, but courts are still saying, yes, we don't want to get necessarily into a 10th Amendment supremacy clause type of debate. We are very interested in making sure that very simple zoning questions are being followed. This distinguishes this line of cases and discussion from other cases where cities have attempted to change zoning to ban the citing of post offices, of other facilities that are less offensive uses. Here, we have the federal government, through its contractors, looking for uses that are dramatic changes. There are certainly unique uses within communities, some communities which don't even have detention facilities at all. And importantly, you're seeing a bipartisan consensus. Cities near El Paso, Texas, a city in Mississippi, my city in Kansas City, suburbs in Westchester County, New York, and so many more being part of the effort as a key step. So, looking to, and I appreciated the comments of one of my colleagues, Professor Chapin, at the very beginning, which was how do we look to unique legal tools to ensure, frankly, the rights of our cities? Another thing that I think that I've tried to speak to in my class, and my God, talk about an interesting time to be lecturing on the Supremacy Clause. I was doing it 3 weeks ago. But what we look to is how do you make sure that you have seemingly content neutral, and so certainly use neutral types of items that don't walk you into an obstacle preemption type of discussion, don't walk you into some of the areas of opposition from our federal partners. So that is, what we're doing in terms of the discussion. It has been robust. I think it is something that you're seeing in every part of our community. And obviously going back to, in some ways, my politics, which are closely informed by legal understanding, both of administrative law, certainly local government law. I've been a mayor for 7 years now, hard to believe, is the simple fact that there are tools that exist in the toolbox for any American city. I encourage you to look to a broader array of lawyers, of legal standards and disciplines, where you're looking at adherence to administrative procedure, which is something that we are seeing used in the Eighth Circuit and the District of Minnesota now, land use law, particularly on distribution facilities that are being turned into encampments of folks, and then always certainly looking at whatever other appeals we may have along the way. Look forward to your questions later. Thank you to our Big 12 law schools for this great conversation. And back to you, Madam Dean, my former colleague.
Yes, I can't believe you've been married for 7 years. You were just down the hallway from me at the University of Kansas. So great to see you succeeding. Thank you for those comments. And that's a nice reminder. He said he's looking forward to answering your questions. If you do have a question, please drop it into the Q&A box, and we will get to question answers later. But first, we have the wonderful Professor Mark Miller, who will speak next.
The Dean Kronk-Warner has left out that she and I have had many engagements over the years because I spent time as dean here at the U of A. But it's a delight to be back in the classroom, and that's what brings me to join this great conversation today. Here at the U of A, we teach our 1Ls criminal procedure, not substantive criminal law, so the investigations or police practices class. And the students in that class have been following the headlines, following developments in Minnesota and elsewhere. And early in the semester, we're asking about the relevance of the materials that we had started to study to federal immigration enforcement and to what they were seeing in the news. So that led me down the path, since early in the term we talk about Terry, of thinking about the use of Terry stops for interior immigration enforcement. In most years, like I expect most CrimPro teachers, I flag the different rules for stops at the border and fixed checkpoints near the border with Martinez Fuerte. I notice the extension but limits on roving stops in Brignoni Ponce. I don't usually focus on interior immigration enforcement. There's so many specialized doctrines, both at the border and internally, and immigration law is its own enormously complex field, but now it seemed was a different time. So instead of what I have done in recent years, which is turn from Terry to look at stops in New York, given all the data, we took what I call a right turn to Minnesota, which always gets a smile, and we take a look at immigration stops. So first, the question students have, and I wanted to confirm that Terry was indeed the proper legal standard for interior immigration stops and interactions. There's no immigration stop exception to Terry. Second, there's a lot of litigation right now that raises Terry-related arguments, pretty much Secretary Noem versus everybody. But in particular, I focused on Noem versus Vasquez Perdomo, the 2025 shadow docket decision, where The Supreme Court removed a TRO injunction that had been largely upheld by the Ninth Circuit, coming out of the Ninth Circuit out of California, and that had looked at factors associated with race and potentially associated with immigration status in making reasonable suspicion determinations. And Justice Kavanaugh had concurred, short, again, shadow docket decision, just noting that it was wrong to rule out these factors, that Terry correctly requires a multi-factor analysis. And almost immediately, this brief commentary was referred to as Kavanaugh stops because he seemed to be embracing the use of race-related factors, and Justices Sotomayor and Justice Kagan, Justice Jackson warned that by removing the limits on enforcement actions, the risk was behaviors that were indistinguishable from racial profiling. So that took me back a step to review and bring in at that point in the course the law on race and stops and see how ICE enforcement fit into that. So going over Brown versus Texas, sort of limitations on non-particularized behavior as a basis for an investigative stop. That led me to expand with the class on this concept of proxy suspicion, again, drawing heavily on Perdomo and the other nometic cases. And what it seems to me, and it may be pedestrian to focus on doctrine in light of all of the news and headlines, but I think the immigration stops are shining a huge light on some of the inherent weaknesses in Terry, including Terry remedies, because suppression has very little to say in the immigration context. And you look at the cases of Nome versus the world, and you see when there is relief, there's systematic relief being offered, and that's interesting. And then it comes back in the end to a question of, well, what insights does this give us on Terry, on the limits of law, on the role of other institutions in addressing systematic either violations or solutions? I thought Emily's interesting opening, as well as Mayor Lucas thinking about the use of law, but different institutional responses, including internal executive responses, are really important insights. I think it's a reminder to my students about how much culture matters, how much broad understandings about police individual relationships, federal-state relationships, sit behind formal doctrine, the limits of doctrine. And then the last point within my 6 minutes is you might be interested that I used AI very heavily as I engaged with the class. And over the course of about 1/10 of the time that it would have taken traditionally, I wrote a 50-page article on exactly the topic we've just discussed and sent it off to law reviews with full disclosure of the source. So just perhaps an interesting aside. I look forward to questions.
I was saying that was the best presentation that I have ever heard. So thank you so much, Professor Miller. And next, we'll turn it over to Professor Morales.
Okay, so I'm going to take a slightly different direction. I titled this, which I wrote today, Minneapolitanism, Citizens Fighting for the Neighbor. The law draws a harsh divide between citizens and non-citizens at the border, but the line has traditionally mattered less in their day-to-day life in the U.S. The 14th Amendment confers most rights to people, not to citizens. And from the perspective of the citizenry, most immigrants lead lives interchangeable from citizens. Migrants are often segregated in certain neighborhoods or towns, but not enough to prevent them being woven into the tapestry of our society. What I think we witnessed in Minneapolis and are still witnessing is what happens when the government starts pulling on these threads, where once everyone in the tapestry was a neighbor, perhaps of a different color, but all of them contributing to the picture. Now the national government, with brutal, terrorizing force, is imposing an abstract, less lived in the flesh social category on certain Minneapolitans based on their immigration or citizenship status. And one way to think through the response we've witnessed from Minneapolitans is to understand them as reasserting the supremacy of non-citizens' identity and value as neighbors. And that's an identity that by these citizens' brave and dangerous actions reveal as more important and potent than the alien category that the national government is trying to give life to. The ferocity and determination of Minneapolitans, whom the government labels citizens of the United States, to fight for the Minneapolitan neighbors, whom the government labels aliens and criminal aliens and drug traffickers and terrorists and fraudsters, I think reveals a lot about what identity actually matters more to people, at least in that context. And so I think this is interesting because, as it turns out, then Minneapolis provides some evidence that's quite contrary to what many white nationalist thinkers talk a lot about, which is the need for people to have a national identity that they are willing to die for. Minneapolitans have shown that neighborliness in certain contexts can drive the same level of self-sacrifice, even as we saw with both Renee Good and Alex Preddy, the ultimate sacrifice. So in asserting the primacy of the neighbor, Minneapolitans, I think, reveal accidentally how the structure and content of immigration law systematically denigrates and invisibilizes the neighbor, even as it works to elevate the abstractions of the citizen and the alien. When many of our great-grandparents immigrated to America, the law acknowledged the way that non-citizens get woven into the tapestry of places like Minneapolis. Many don't know this, but the statute of limitations on deportation then was 5 years. After that, the national government was barred from deporting an alien because that person was a neighbor now, right? Consider today that the median undocumented neighbor has lived in the US for approximately 15 years. In the era of our great-grandparents, that means most of the undocumented population would be legally undeportable at this time. Now, though, with that statute of limitations long gone many decades ago, and in an era of ever-increasing expenditure on enforcement sanctioned by Democrats and Republicans, immigration law has for many decades been more quietly acting on the same citizenship elevating and neighbor denigrating impulse that Minneapolis deployment made so visible. I think one question to ask in the aftermath of Minneapolis is, how can we build on the category of neighbor to sustain and support resistance to the immigration system's violence, which surely with time will return to fraying the tapestry that I introduced more quietly. Another deeper question to think about that I think about a lot, and I think that the neighbor frame makes so clear, is why does the federal government have the legal right to kidnap our neighbors, right? Sovereignty. What Minneapolis shows is the need for localities themselves to have some sovereignty, or at least a say in when an alien becomes a neighbor and is thus too enmeshed in the tapestry of the local for the national government to render deportation just. Minneapolis put on full display the dangerous over-centralization of the immigration power in the national government, as does the development of the warehouses that have already been discussed by others. I think localities long ago played a more substantive role in immigration policy. Perhaps they should again. Thank you all.
Great. Thank you so much. And last but certainly not least, Professor Matt Toxin.
All right, thank you. And excuse me, I like your background, Elizabeth. When I was thinking about some of the interesting Fourth Amendment issues surrounding Minneapolis and ICE, so many of which have been touched on by my fellow panelists, to me, one of the most interesting was, we saw examples in Minneapolis and in Chicago of ICE agents breaking into houses, including U.S. citizens' houses, dragging people outside, some of whom were citizens, and why we were seeing that, and were they worried? I think a lot of people's reactions were, oh, weren't they worried that they would get in trouble for violating the Fourth Amendment by breaking into people's houses without a warrant? And the answer is no, because I don't think there are real Fourth Amendment remedies in this context, as Jacqueline Green was touching on a little bit earlier. And that, to me, that's something that's really interesting about this whole context. It points up why Fourth Amendment remedies are so important, because without them, the authorities basically don't have to care about whatever your Fourth Amendment rights are, right? I usually think about what are our Fourth Amendment rights, and how do they apply. Here, it sort of didn't matter, right? The rights basically don't exist in practice, which I find interesting. So if we look at Fourth Amendment law more broadly, we sort of see a similar effect in terms of the importance of remedies. Fourth Amendment law really became extremely important to the daily practice of policing after a case called Mapp versus Ohio in 1961, which developed the modern exclusionary rule, expanded it basically to the states and to every case. And that was when Fourth Amendment law, mattered. But prior to that, but that's when it really became a big deal that every sort of police officer in the country had to care about. And that's when the development of Fourth Amendment case law really came into its own. The exclusionary rule is a sort of important remedy because if you want to ever get a conviction, you'll need evidence, and if key evidence is excluded because there have been violations of the Fourth Amendment, your case is likely to get thrown out. So everyone in the criminal justice prosecution context cares about evidence and cares about exclusion, and accordingly, they have to care about the Fourth Amendment. The not every case involves evidence to be excluded, even in traditional police contexts. In some cases, there's not evidence that they want to exclude. It's just sort of innocent people having their Fourth Amendment rights violated. Typically, those people can have their rights vindicated by a lawsuit if we're talking about state and local law enforcement officials. Thanks to the Section 1983 civil rights statutes, you can bring a lawsuit against the state and local officials. If you win, your attorney will get their fees and costs largely paid for or entirely paid for. There are also punitive damages available against the individual under 1983. So this is not as big a deal as the exclusionary rule, but it's often a robust remedy. Likewise, if you're suing federal police agents under a Supreme Court case called Bivens, you can sue them. Bivens has been cut back repeatedly over the years. And a big way that's been cut back is in federal immigration enforcement. So in a case called Hernandez v. Mesa, there was a cross-border shooting, a shooting from an officer in the United States across the border to Mexico. And the court said, this is not covered by Bivens. There's no remedy, federal lawsuit remedy against these officers. This is a national security issue. It's a border issue. And so we're not going to extend Bivens to this issue. And then really the big case for the Minneapolis context, Egbert versus Booley in 2022, I believe, where the court said even if it's not cross-border, even if it's enforcement within the United States and within a state, there's still no Bivens remedy for Fourth Amendment violations by immigration officers doing immigration work. Now, in 2022, this wasn't like a huge earthquake in the law, but I think it's become one in the sort of modern era of ICE and of Minneapolis and everything else. In addition to, it shuts off, in other words, the main federal remedy for constitutional violations against federal officers. And I don't want to say that they're allowed to operate with impunity, but there's not a whole lot of effective remedies, in part because, as Jacqueline Green mentioned, the Federal Torts Claim Act isn't much of an alternative. That's sort of the open alternative, but there's a whole bunch of hurdles, like the no discretionary acts hurdle that she mentioned. There's also no automatic award of costs, and there's a cost limit. There's no punitive damages. There's lots of other procedural hurdles. It's just not a very effective remedy. There's the Westfall Act that says you can't sue officers in their individual capacity for tortious acts within the scope of employment, so you're sort of up against the United States anyway. And so I think the lack of effective remedy is a huge part of the story of what we're seeing. And it can be hard even for excessive forces claims, which might have huge damages, to get off the ground as a result of all these things. And as a result, it's tough to get purchase on the Fourth Amendment law of it all, because it just doesn't seem to matter in practice, which is concerning. One point I'd make about this approach is that it's sort of anti-originalist in a lot of ways, right? Among many other issues with it. At the founding, people sued government officials in their individual capacities and often received crushing, punitive, like high punitive damages. The This was the system, and this was what the Fourth Amendment was meant to preserve, was a robust tort remedy system against federal officers who violated violated rather tort law, who trespassed on your house unlawfully without a warrant. And these unlawful trespasses were strongly deterred by the threat of tort liability. It was true of colonial officers, but especially true of English officers who often got like writs of assistance and other general warrants to go inspect the colonists' houses for seditious papers and stuff. And they were strongly deterred because colonial juries would often issue punitive damages against them for violating homeowners' rights. The another In closing, I guess I'll say that Congress could fix this if it wanted to by creating a cause of action for lawsuits against officers who violate the Constitution. But right now, we don't really have an effective remedy, and we're seeing the effects of that in Minneapolis. Thank you.
Great. Thank you so much, Professor Toxin, and a big thank you to everyone. I forgot to mention earlier, we pulled together this panel relatively quickly, given kind of the newsworthiness of the topic. And so I really appreciate all of our wonderful presenters for taking the time on relatively short notice to join us here tonight. So again, if you have a question, feel free to drop it into the Q&A box, and we'll start with you, Mayor Lucas. A couple of questions for you. First, we see, how do you see organizations doing KYR and other efforts right now? Can't cities prevent ICE agents from staging and organizing on city property? I believe the St. Paul mayor passed such a law. Are there other ways that they can prevent ICE agents from staging? What else is possible in non-cooperation by city police with federal agents?
I think there are a few steps. First, I have seen the staging legislation. I think that, that certainly works. That tends to be a frustration of different efforts, but it more broadly shows noncompliance. And so I think probably one of the best tools that I've used thus far as a mayor is different than the organization listed, but the Public Rights Project does a good amount of work with American cities and, frankly, state and local governments. That, to me, is an important part of it. We are seeing constitutional testing around the country, so that is, I think, a key step one. Law enforcement presents another area, and I mentioned commandeering and anti-commandeering standards before, really going back to some great cases, Prince versus the United States, for example, that speaks to the fact that we cannot be compelled to comply necessarily with federal enforcement schemes. And so therefore, I think it is in some ways more internal as to where is the city seeking to take steps to protect its constituents, finding the fullest extent possible that it can do it, and then looking at where ICE engagement is in your community, recognizing it's different in every one of our cities. And I think that's where we have looked to build most of our legislative work. Staging, not the same amount of issues arising as we had from actually looking at warehousing humans in Kansas City. That being said, we're gaining from each other, and that's where not just nonprofits, but also law schools become very important.
I think you're muted, Dean.
I did it again. Wow, in 2026. Apologies. So next I see what I believe was initially a question for Professor Miller, although if anybody else would like to jump in, you are more than welcome as well. So the question is, we're talking about Kavanaugh stops in Tucson. What can we do about it?
So I think some of what we heard earlier applies here. And one of the themes, I think Matthew's comments go to this as well, is that relying on courts and traditional legal process to respond to what is this extraordinary moment where we're not seeing institutions behave in a normal way is unlikely to be sufficient. I'm not saying litigation isn't important, and I'm sure not saying that being creative about legal claims isn't important, but here in Tucson, there's been substantial presence of citizens, students, people who are interested, again, recording, watching, discussing. There's very active social media presence. I think all of that is very important. The level of interest in and overwhelmingly, though not absolutely, opposition to, for example, the potential development of very large detention centers beyond the large facilities that have long existed because we're near the border, is leading to a lot of discussion within city councils across the state and very much in the community. And so I do think these broader, some political pressures, the chance of having all three branches perhaps engaged, thinking of government in this dynamic way, absolutely being attentive to local and county governments and not treating it as if it's simply a federal conversation. I think all these things are pathways to ultimately shape a world people will be happier with.
Great. And we have 4 minutes left and 2 questions. So I'm going to ask the 2 questions, and then whichever of our panelists would like to jump in to answer those would be great. So the first question comes from Will Baynard, who asks, in trying to advocate for remedies for privacy violations, for example, misuse of state juvenile records or Fourth Amendment violations, has anyone approached this on a, quote, no right without a remedy, unquote, basis? And how was that met? And then the second question that I'll tee up is, are Section 1983 claims being filed in instances of overreaches by federal agents? Professor Toxin, I see that you have put your video on, so I'll go to you.
Sure. Well, so on the 1983 question, 1983 only applies to state and local officers, so it can't, at current time, be applied to federal officers. Some people have advocated to extend it to federal officers, and that would be the legislative solution to the remedies issue. But so far, 1983 isn't a vehicle for this. And then on the no right without a remedy argument, I mean, I think one thing I'll say about this is, it has sort of been tried rhetorically with some success in some cases and no success in others. In Egbert and Hernandez v. Mesa, the court has said, like, oh, well, there's a remedy in the sense of you can, like, petition the Department of Homeland Security and complain and they'll investigate it, and that's your remedy. And, like, that's fine, but that's not obviously like a tort remedy, let alone like a Section 1983 remedy. And I don't think it's really going to get you very far or vindicate your rights. So I don't think the court, in other words, I don't think the court like is that concerned about the no right without or anything, but this hasn't been tested since 2022-ish there. So they may feel differently. I'm not sure.
Great. And Professor Green, I see that you turned your camera on.
Yeah, 9J3, like Professor Toxin said, is so limited, and there are so many limited remedies available at this point. I think one of the interesting things that is happening, and I know litigators in Minnesota are working on this, is creative use of the FTCA, which, as we discussed earlier, and Professor Toxin reference, is really limited. It has a lot of problems in terms of actually reaching the kinds of, just answers to the issues that are going on. But there are people who have argued and are arguing, and there has been some success in the past, to use the idea that your constitutional rights, what the Constitution requires, gives rise to an analysis that would say that the act at issue, whatever the law enforcement agent did, the federal agent, is not discretionary and therefore should be subject to a continued litigation process under the Federal Tort Claims Act. So that is one thing that we're starting to see, and is, I think, probably a vehicle that's going to get used more and more for federal agent related litigation. And one other quick thing I just want to respond with is, I think we're talking a lot about rights and safety on the ground right now are often two really different things, and the access to remedies, immediate in the moment for safety issues and in the long term, is a real question and real issue that I think people are really going to have to grapple with in the courts and outside, as we've heard other panelists discuss.
Great. Well, thank you so much. I want to thank our panelists again. That was just a wonderful presentation, and I feel so fortunate to be part of the Big 12 with just such spectacular faculty who are willing to share their thoughts with us. If you're interested in our next Big 12 collaboration, we are hosting a virtual collegiate sports law CLE that overlaps with the Big 12 championship, men's basketball championship tournament, which I'm sure will be both a wonderful tournament and a spectacular CLE. That's going to be on March 25th from 2 to 5 p.m. Central Time, and it's going to be hosted by our colleagues at the University of Houston Law Center. So again, thank you so much to our wonderful panelists, and thank you to you who joined us tonight. And Che Miigwech, thank you very much.